Yeah, so just before the power interruption, we're making the point that Fuller contribution to natural law focuses more on procedural dimension, and especially what he calls morality and the idea of rule of law. And we said he makes the point that law is the purposeful enterprise of subjecting human behavior to certain regulation in order to enable human being achieve satisfactory or flourishing life. And for that matter, he is interested in finding out the relationship between the means and the ends. So the end is the satisfactory life, and the means is the law. So the laws that you are making, in terms of the processes involved and all that, are they properly crafted to enable attainment of this end, that is the satisfactory life? And Fuller sought to show that the process of legislation was governed by objectively determinable laws, which were natural. These are the goals which a legal system must achieve to qualify as a system of law. So that is the point that he's making. And what are these? In Fuller's thinking, the goals which a legal system must achieve include: one, there should be rules in the first place as opposed to a series of ad hoc judgments. So he says that, yes, if we are talking about rule of law properly conceived, then there should be rules in place first. You shouldn't have ad hoc judgment. It shouldn't be a situation that, as and when there are situations, then we will now make the rules to govern those situations. The rules must be there first. The law must be there first. Two, the rules must be made public or known to all those affected by them. Now, let me go back to the first point, that there should be rules in the first place, as opposed to a series of ad hoc judgments. Now, if you take Ghana, for example, if you take Article 19 of the Constitution, there is a provision that no one shall be punished for an offense unless it has been defined in a written law and punishment prescribed for it. So that is what our Constitution says. So that is to say that, yes, before we can actually say that a person has committed an offense, that offense ought to have been defined in a law which already exists and in punishment prescribed for it. And that is consistent with Fuller's point that there should be rules in the first place as opposed to series of ad hoc judgment. Then two, and then just before we move on, remember the famous Aisha 1 case, the Chinese woman who was alleged to be involved in, I think, galamsey or something like that. And when she was found guilty and convicted by the court, I think she was given punishment, if my memory serves me right, it's about 4 years or less than 5 years. And people were outraged as to why she was given a shorter jail term. But that was the law in force at the time that she was arrested and charged. So it was later that that law, like the new one, had come into force and all that. So Fuller says that there should be rules in the first place as opposed to a series of ad hoc judgments. Then two, the rules must be made public or known to all those affected by them. So one objective criterion of a legal system in Fuller's thinking is that the rules should not be secret. Everyone should know the rule. So if you take Ghana legal system, okay, the power to make laws, for example, if you look at Article 93 of the Constitution, is vested in Parliament. Now, if you look at Article 106 of the Constitution, Article 106, 106 has provided the mode of exercising legislative power. Then, when you also go to Article 11, Clause 7, when it comes to subsidiary legislation or delegated legislation, there's also a mode of exercising it. Now, in all those provisions, one thing you observe is that there is a mention of what we call gazettes. The fact that the law should be gazetted or should be published in the Gazette. And that reflects what Fuller is saying, that the rules must be made public. Because what is a Gazette? Gazette is the official medium through which the state communicates to its citizens. So if something is put in the Gazette, it is deemed to have been made public. And that is the foundation of the legal maxim that ignorance of the law is no excuse, because part of the process of lawmaking is that it will have been gazetted. And once it is published in the Gazette, it is considered to have been made known to every citizen. So let us keep that in mind. And three, the rules should not have a retrospective effect. The rules should not have a retrospective effect. That is to say that you cannot make a law which says to govern matters which have already taken place. So that is a retrospectivity. The law must have prospective effect. The law must govern things which are yet to happen and not things which have happened already. And again, if you look at the constitution, so there's a provision even against retroactive legislation as well. Then four, the rules should be understandable. Fuller is saying that for a legal system to be fit for purpose, then the laws or the rules should be comprehensible, should be understandable. The law is a means to an end, it's not an end in itself. The end is attainment of satisfactory life. So if people are supposed to use the law to guide their path, they must actually understand the law. I mean, that is the point that we are making. They must understand the law. So if you have a law which is not understandable, then how can it guide people? And that is why we also have in the whole Interpretation Act, we have a whole rules on interpretation, which are meant to help to unpack the law and to unravel any ambiguity that may be embedded in the law. Fuller also says that the rules or the law should not be contradictory. So if you read Fuller's original work, he uses various allegory. He uses like his own stories. And he used the imagery of the Rex 1, Rex 2, like the young prince who, assumed the throne to reign. And when he came, he experimented so many things. And the various things that he did will provide the basis for Fuller to demonstrate what a legal system should not be. And it is on basis of that Fuller distilled these objectively determinable criteria or standards or desiderata as to what should be reflected in a legal system. So he said that the rules should not be contradictory. In other words, the rules or the law should not say one thing and say another thing which contradicts that which said earlier on. That way, it becomes confusing for those whose lives are supposed to be governed by it. And that is why when you are doing interpretation, there is a presumption that the lawmaker is consistent, presumption of consistency that the lawmaker does not contradict himself. Fuller makes the point further that the rule should not require the impossible of the people. You shouldn't make a law which require people to do that which is not doable. That is the point Fuller is making. Otherwise, that law will be outmoded at birth or dead on arrival. Or you are certain to realize that nobody will obey it because what the law is saying cannot be done. The 7-point Fuller makes is that the rule should not be subject to frequent or arbitrary change. So, if people are supposed to govern their life by law so as to attain satisfactory life, then the law should not just be changed, just like that. So that is the point which Fuller is making. And that is why, if you look at Article 106 of the Constitution, if you are making a law and, for example, we are going to make changes, you are supposed to tell us what the problem with the current law is and what the proposed solution is. So you don't just be changing a law at will. And that is why in Ghana, when it comes to the constitutional reform debate, we need to hasten slowly. Every now and again, people will make a pronouncement. Let's amend the Constitution. Let's amend the Constitution. Let's scrap Article 71. Let us take away powers of the president. Let us do that. All those are interesting suggestions, but you come back to Fuller's thinking, and Fuller will say that the rules should not be subject to frequent arbitrary change. Our Constitution, for how long have you operationalized it? That's about 30 years. Some people have operated their Constitution for over 200 years, and they have not made significant changes. Now, the 8th point Fuller makes is that the rule as announced should coincide with the actual administration of the rules. In other words, when rules or laws are made, when it's time for enforcement, effect should be given to the rules. And that is what judges, judicial would actually require them to do, to uphold the laws of what? Of the country, without fear or favor, ill or affection, and to do justice to all manner of what? Of people. So, Fuller makes the point that the conditions that we have just discussed, the various 8 things, or what we call it, the desideratum, comprise the morality that makes law possible. And since this morality is internal to the law itself, it is termed the inner morality of law. So Fuller says that if you examine law, you are supposed to see these things reflecting in the law or the legal system, in the internal to the law, and that is the inner morality that he's talking about. Therefore, if there's a positive or man-made law, and these features are lacking, then it is not law in natural law thinking, to use the Fuller's reasoning, so to speak. Then we also have another important contemporary natural law thinker called John Finnis. John Finnis is very important in the sense that if we take, even before Fuller, if you take the various natural law proponents and all that, they will be talking about general claims about natural law without giving us a lot of specifics in terms of substantive natural law. Now, Finnis, who is an Australian jurist and philosopher, appear on the scene, and he attempts to develop natural law thinking in a way which will help us to see it in concrete terms. Now, he was influenced by the teleological theories of Aristotle and Aquinas. When we say teleological, that is teleological, the telos come from purpose or goals. Aristotle and Aquinas, all of them hold the view that human beings, we have purpose. Law has a purpose. So that is why I said that law is teleological. So in Finnis's view, society has purposes and significance, which can only be achieved by an appropriate system of law, and finding an appropriate system is a concern for the jurist. So starting point, yes, society is not just aimless. We are not here as a suicide club just to perish and go. We have a purpose. So how do we achieve this purpose? We need a system of law which will help that. So if you're a jurist, if you're a legal philosopher, your concern should be to probe or to explore how best law can be mobilized to enable the purpose of letting human beings achieve a satisfactory life, or what we call like the human flourishing. So by human flourishing, which is one of the very important purposes of life and society, Finnis meant whatever constitutes a worthwhile and valuable life. So what makes life worthwhile? What makes life, valuable? So that is the human flourishing. Now, commentators hold the view, and rightly so, that Finnis's contribution to natural law is a modern restatement of natural law. What specifically did Finnis propounded? To Finnis, there are certain basic goals which are self-evident because every reasonable person must assent to their values as objects of human striving. In other words, Finnis maintains that if we accept that the purpose of life is human flourishing, to enable human beings have a worthwhile life, a meaningful life, then we will notice by observing human life that there are certain things, what they call basic goals, which are objectively and unquestionably necessary for everyone. And no reasonable person, no thinking person will deny that. What are these? You identify life. That when it comes to life, nobody will deny that life is a basic good. In any case, if you take, because you are the Presbyterian University and you are located in the Ashanti region where they speak the Asante tree, I use the anecdote of Asante anthropology and proverbs to layman's discussion from time to time. So among the people of Asantes or the Asantefo, they will say that now can anybody explain it before I move on? Anybody? Now can anybody explain that? Hey, you're schooling Kumasi and you don't understand any of the proverbs. Put up your hand if you want to speak. Oh, okay. You can unmute yourself and make sure that only one person is unmuted at the time. Yes, who can explain that?
Cancel. Cancel.
I'm not cancel. Go ahead.
Okay, my lord.
Yeah.
My lord, it means life is so precious. So if you have life, then you have something very valuable. That's what it means.
Okay. Okay, that is fine. Any other? Yes. Is it, who spoke? Is it Emmanuel Bobe?
That's so, my lord. That's so, my lord.
Okay, Mr. Gogo. Yes, you want to ask something? Mr. Gogo. Reginald, your hand is up. Gogo, your hand is up. Speak. Okay.
Yes, my lord. My lord,
yes.
What it means is that you have everything.
You have everything. Okay. Okay. All right. Finally, let's take a Sharon. Okay. Sharon. Patience. Okay. All right. Let's move on. Good.
Yes, my lord.
Yeah, your hand is.
It means that, yes, my lord.
Okay.
It means that if you have life, the tendency of you achieving your aim, your dreams, is high. But that of the one who is already dead, everything is shut and ended. So there is hope to forge ahead.
Yes, yes, yes. Absolutely, yes. So life, being alive, is everything. If you are not alive, nothing matters to you.
Yes.
If you are alive and you don't have even a place to sleep, you don't even have food to eat, you don't have, at least you have something to start with. So life is everything. And this life is saying is a basic good, is discernible from our drive for self-preservation. When we say self-preservation, the fact that you want to do everything necessary to keep ourselves safe, to keep ourselves alive. And also, you want to reproduce ourselves. It is natural for human beings and even irrational creatures like even animals to want to reproduce themselves, to want to keep themselves from harm. When you're driving and you're getting closer to a sheep or a goat or any animal, as soon as they sense emotion getting close to them, they'll try to run away because they know that danger is what? It's coming. Even for irrational creatures, they have the drive for self-preservation. Procreation to the same thing. There are times human beings will engage in sexual intercourse, not only for pleasure, but for procreation. And in fact, Finnis was a Catholic scholar. If you take the Catholic Church, conventionally, the thinking has been that the act of sexual intercourse is supposed to be for procreation. Another basic good is knowledge. Knowledge, Finnis opines, is a good in itself to be well informed rather than ignorant or muddled. Human beings, we naturally don't want to be ignorant. We want to know what is happening around us. And in fact, that drive, we take it to a extreme. And that is what even manifests in gossip. Because, I'm talking about the positive gossip, not negative gossip. Like positive gossip, as we try to find out, what did he come here to do? Yesterday, what happened when I was sleeping or when I was not there? You want to know, you want to understand, you want to avoid ignorance. So knowledge is not talking about instrumental knowledge. Instrumental knowledge is like what you are doing. You are learning law, not because you just want to know the law. I'm sure most of you are not learning law because you just want to know the law, because you want to become lawyers, you want to become judges, or to become legal people. That is why you are learning the law. So you are learning law as a means to an end, not an end in itself. But Finnis is saying that knowledge is an end in itself, and he's talking about knowledge as opposed to ignorance, like you knowing for the sake of knowing. That is what he's talking about. He's not talking about like the knowledge that like you just go to school to get certificates and all that. No. And then play. Play is also a basic good. It's something which, according to Finnis, is needed, is innate to every human being. When he talks about play here, he's talking about leisure. Leisure. Like, leisure means when you are not doing work you're supposed to do, what do you do to break boredom? That's the kind of thing he's talking about, that all of us, we have some form of recreation, some form of enjoyment, some form of fun. It doesn't mean you should be a soccer fan or a football fan or tennis or boxing, but some activities other than your usual work. That's what it means by recreation. That's what it means by play or leisure. Then he also identifies aesthetic experience. So by aesthetic experience, Finnis makes the point that it is an appreciation of beauty in art or nature, that all human beings, we have that natural quest in us to admire beauty. And for that matter, if you see something beautiful, even if you don't open your mouth to say it, within you register it or you acknowledge it in you that, oh, this is beautiful, this is ugly, this is nice. It's part of us. So if you see artwork or you see nature, you see something which is admirable, you see it. And of course, on that, let me say that even if you take even like a beauty as in human beings, right? If you take like a man and woman working together, you see someone, the person is handsome, the person is beautiful. it will attract your attention because there's that quest in you for you to appreciate beauty. Or you are taking a walk, you see beautiful flowers, or you see how the clouds are formed and you see some beautiful, these are all aesthetic experience and it is innate to everyone. So no human being, according to Finnis, will say, that's for me. I don't care about whether something is beautiful or something is not beautiful. That is really not true. He also identified another basic good called sociability or friendship. Sociability or friendship. We often say that no man is what? Is an island. We are all connected to one another. So Finnis said that all human beings, we have the quest for friendship, the quest of being sociable. Try to act in the interest of one's friends. It's part of that. No human being can say that for me, I want to live and I don't want to care about any other person. And he also identified the practical reasonableness. Now, before, let me say a bit more about the sociability. In modern times, okay, there's an observation I have made. And with the advent of social media, Facebook, Instagram, Telegram, Snapchat, whatever, name it, you see that some of the things Finnis is saying are verified. Let me give you practical illustrations. When you are there are times that you post a picture of yourself, right? You post a picture of yourself on the Facebook or on your status, WhatsApp, or some social media. Why? Why do you do that? Why don't we just get an album in your house and then you just put the picture there and you look at it yourself? Why? There are times that you put up status statements. Why do you do that? Why don't you just have your own private notebook and whatever you are thinking, you just put it there for yourself? Because you are not an island. You want to associate. You want to be sociable. And that is why you do that. And it is a validation of some of the observations that Finnis is what is making. Then practical reasonableness. Employing one's intelligence to solve problems of deciding what to do, how to live, and shaping one's character. So how you bring your mind to organize your life, make right choices, so that you are able to secure or realize all these other basic goals is what it means by practical reasonableness. So if you take there's a writer called Rick Warren. He wrote a book, Purpose-Driven Life. What on earth am I here for? And then another guy called Stephen Covey, he also wrote a book, 7 Habits of Highly Effective People. They are all a reflection of what Finnis is calling practical reasonableness. How you apply your thinking ability to solve problems, making a decision as to what to do, how to live, how to shape your character and all that, so that you have a flourishing life, your life is worthwhile. Then religion. Religion is another basic good. And by religion here, Finnis is talking about things that transcend our individual interests. So the transcendental experience. In other words, Finnis is saying that as human beings, there are times that we want to reach beyond ourselves. And beyond ourselves, not to another human being, no. Like, we want to connect beyond the human experience. So that quest to connect beyond our individual interests, our human experience. So that is religion. That is religion. And whether you say you believe in God or you don't believe in God, you have that quest for religion. That is the point Finnis is trying to make. Now, these 7 basic groups which Finnis has identified, they are probably not exhaustive, but I think he identifies 7, but later scholars will take the view that it's possible to add to it, and some will even add work. I think some other scholars have added like work, that if play is innate to us, then work is also innate to us, because if you look at human beings, we all know that we need to work before we can live a meaningful life. If you are not working, how will you eat? You have to still, isn't it? And all that. To some, we even go to the sense of adding work to it. Alexis, put your mic off. It's giving us a feedback. Now, Finnis 7 basic rules are combined with 9 principles of practical reasonableness. Now, when we say practical reasonableness, he has already told us that employing one's intelligence to solve problems of deciding what to do, how to live, shaping one's character. That is basically what he means by practical reasonableness. And this practical reasonableness has various manifestations. And what are these manifestations? One, the good of practical reasonableness structures the pursuit of goods. It shapes one's participation in other basic goods by guiding one's selection of projects, one's commitments, and what one does in order to carry them out. So the practical reasonableness become like a compass, become like a guide. And that enables you to even enjoy or pursue the other basic goods like life, aesthetic experience, recreation, religion, and so on. Another principle of practical reasonableness is a coherent plan of life. Coherent plan of life here, it means the fact that one ought to have a harmonious set of purposes as effective commitments. You must have an organized life. You must have an organized life, and your life should be geared towards achievement of your goals. So you are students learning law now. How do you plan your time? How do you decide what event to attend, what not to attend, so as to make more time for your studies? And yesterday we were celebrating people who excel in the law school graduation and all that. So very soon you too will be there. So how do you plan your life? You want to become a good lawyer. So how do you plan your life so that you become like a good lawyer and so on? So you must have like a coherent plan of life. It's part of the practical reasonableness. There are no arbitrary preference among values. One principle of practical reasonableness is that one ought not to omit or unreasonably exclude or exaggerate any of the basic human values. So none is important than the other. So don't put religion over, let's say, aesthetic experience, or don't put knowledge over practical reasonableness, and so on. But one may ask whether life may probably not rank number 1, because based upon the discussion we did not too long ago. If you don't have life, can you really do any other thing? But Finnis is telling us that one principle of the practical reasonableness is to avoid arbitrary preference among the values. You don't elevate anyone over the other. Then the fourth principle of practical reasonableness, in his view, is that there should be no arbitrary preference among persons. You must maintain impartiality in regard to yourself and others' interests. So that is to say that you don't have to be self-centered. You don't have to be biased. Let us keep that in mind. Then the fifth principle of practical reasonableness, detachment and commitment. One should be both open-minded and committed to one's projects. In other words, we must have an open mind. We must have an open mind, and that notwithstanding, we should also not lose focus. You should be committed to what we have set ourselves doing. Then 6, the limited relevance of consequences. That is efficiency within reason. One must not squander opportunities through inefficiency. Action should be reasonably efficient. In other words, you don't have to get distracted. You don't have to get distracted. You left home going to school. You get to a place, they are having a fun fair, a street carnival, a lot of fun, a lot of drinks, a lot of good music and dancing, great men, beautiful ladies and all that. Then you park your car, you join the flow. You are drinking, dancing, and amusing yourself. You don't go to the class. So that is, you are squandering opportunity through inefficiency. You are being inefficient. So action should be reasonably what? Efficient. You are supposed to go to school, go. Respect for every basic value in every act. One should avoid acts that achieve nothing, but damage or impede one or more of the basic forms of human good. And then the 8, the requirements of the common good. One should act to advance interests of one's community. So the interest of the community is very important. The common good, summum bonum, is very important. So we must always act in furtherance of the common good, the collective welfare of society. And this brings about the menace of Galamsey, destruction of the environment. Why people who are interested in getting money, right, would like to create poisonous environment for population. People who want to get money would like to do ritual killing, like those who do these are ritual many people, right? So they are not acting to advance the interests of the community, but only their selfish interests. Then the 9th principle of practical reasonableness is that following one's conscience, one should not do what one feels should not be done. So your conscience is very important. If you're in a workplace, you have to do something and your conscience is not right, your conscience is pricking you that you shouldn't do it. You have to be true to your conscience. So that is the 9th principle of practical reasonableness. So as far as Finnis is concerned, the combination of the principles of practical reasonableness, which we have looked at together with the 7 basic goals, which we discussed earlier, leads to the immutable and universal principles of natural law. So for him, if you talk about principles of natural law, which are universal, which are mutable. These are the principles of natural law. That is what Finnis is talking about. Hello? Yeah, I'm teaching. Please, I'll call you back. Okay. These are the principles of natural law. So, as you will notice, he has attempted to distill. If you say natural law, okay, what are they? Yes, natural law, there are 7 basic goods, said 7 fundamental things, which you cannot get anything more important than those. You know, what we went through: life, recreation, aesthetic experience, religion, and so on and so forth. And then the 9 principles of practical reasonableness, how to organize oneself so as to realize the basic goods. So Finnis will say that natural law is the set of principles of practical reasonableness in ordering human life and human community. And it is a practical, reasonable person who can grasp these basic values and the law's purpose in realizing them, who can rightly describe the law. So, human law, man-made law, is supposed to help us in attainment of this natural law, understood in the sense that you talk about. That is the set of principles of practical reasonableness for ordering human life and human community. Of course, Finnis's ideas are interesting, just like so many other natural law scholars. But in law, particularly in jurisprudence or legal philosophy, no idea is sacrosanct, and every school or every school of thought has its own flaws or weaknesses. So, David Hume, for example, would make the point that knowledge not based on experience has no value. So if you take natural law, generally, natural law is heavily steeped in metaphysical claims, abstractions, and the precepts cannot be concretized most of the time. For example, David Hume will ridicule natural law and says that it is totally meaningless. Why? Because it attempts to derive an ought from an is. So ought is the like what you like the law to be from what the law is. So we're saying that what the natural law people are trying to do is that yes, this is the law, but instead of just concentrating on that, they rather want to look at what the law is and use it to extract what the law ought to be. And David Hume find that to be quite senseless or meaningless. Another scholar, Jeremy Bentham, also has his own criticism of natural law, and his argument is that natural law has subjectivity, which is antithetical to the concept of sovereignty. So, for example, if you look at the idea of sovereignty later on, when we are discussing legal positivism, when you say that law is the command of the uncommanded sovereign. Now, to Bentham, the fact that people will have to make a judgment as to whether the law is just, whether the law is unjust, and for that matter, should my conscience obey it or should my conscience not obey it? These are matters which undermine or which are opposite, which are antithetical to the concept of sovereignty. Because if, in his thinking, law is the command of the uncommanded sovereign, then who are you to question whether the law, which is Royal Majesty Otumfuo, or the law which Parliament and the President have made is just or unjust? So he finds that really questionable. And in Bentham's view, it will lead to endless revolution, because when a man feels that the law lacks some criteria, which is based on his conscience, he is thus impelled naturally to rise up against the law. So just like what we are facing, let me give you a typical example. I'll use the example which applies to the judiciary and leave the rest to you to work them out. I think recently there was a demonstration targeting the judiciary, and for that matter, our boss, the chief justice, regarding the case pending before the Supreme Court relating to that in the LGBT bill or something, which has been decided. Now, if you look at that, case, that situation, right? For example, let's be very objective and think, very critically about it. Just imagine the number of cases in the various courts, the district court, the circuit courts, high court, court of appeal, Supreme Court, okay? In the 16 regions of Ghana. If people whose cases have been pending for quite some time, some people have their case been pending for about 5 years, 4 years, 3 years, and sometimes 10 years. If people can just go on demonstration and put pressure on the judge or the court before whom the case is pending, that yes, we want you to give judgment, otherwise we won't go home, or otherwise we'll come back and take over the court or something like that. You can imagine the chaos which we have, isn't it? Then Alfred Ross also assessed that the principle of natural law were neither eternal nor immutable, as they have been used to argue either for or against any conceivable human endeavor, for example, slavery. So Ross is making the point that if natural law is truly universal and unchangeable, why is it that at some point in time, slavery was permitted to be done? And now, universally, if you look at the Universal Declaration on Human Rights adopted by the UN 1948 and all that, there is a total ban on slavery. So what has changed? At the time that slavery was done, had natural law been suspended, or natural law had gone to sleep? So that is the kind of criticism Alfred Ross is making against natural law thinking. Yeah, so I will take your questions at this stage before we end the session. And yes, Mr. Brobe.
Hello, my lord. Thank you very much. My lord, thank you so much. I really appreciate the work of John Finnis. My lord, am I right to say that if you look at the work of Thomas Aquinas in his work of natural law theory, although he did not specifically list human basic needs in the modern sense, but he did identify fundamental goods that humans naturally seek. And he made mention of life, reproduction, education of offspring, seeking the truth, living in society, and avoiding offense, worshiping God. My lord, am I right to say that when you look at John Finnis' work,
yes,
it was rightly built upon Thomas Aquinas' work?
Yes, you are right.
That's why consideration.
Yeah, you are right. That's why we said in the beginning that he drew heavily upon Aristotelian system, or Aristotle's work, and also Thomas Aquinas. Yes, so you are right. And don't forget that Thomas Aquinas was a Catholic priest, and John Finnis is also a Catholic scholar. And yeah, so you are right. There's a significant resemblance. Yes, any other?
Thank you very much, my lord.
Thank you. Okay, so you start reading legal positivism. I think somebody has something in the chat. What is it? Okay, all right. All right, so have a good day then. Thank you.